from the state to federal level, privacy rights versus the public's right to know has been a subjective issue that goes beyond the courts. Author, professor, and former journalist Amy Gajda explores how the tension between First Amendment and privacy rights has developed within digital media in the modern age. Gajda's new book, Seek and Hide, The Tangled History of the Right to Privacy, dives deep into the history of freedom of the press in America and the impact that it has on privacy rights and the public interest. Amy, we thank you so much for joining us tonight.
Oh, thanks so much for inviting me.
So what influenced you to write this book?
I think my work as a journalist and coming to understand being a lawyer and then realizing that there's this whole area of law that I didn't really understand with regard to privacy, but then also having a number of people suggest to me that privacy doesn't exist anymore, that privacy was something from the past in the age of the internet, and that's not the case. And so what I wanted to do was, in effect, celebrate this privacy right, inform people about it, and then also explain about this tension between privacy and the right to know.
So you feel that privacy does still exist. Explain how subjectivity impacts the need for the public's right to know versus protecting the right to one's privacy.
Sure. So for the first example is that when someone requests information from the government through the Freedom of Information Act or otherwise, there's a person there on the other end who decides whether or not that information is too private to be released. So there's that example. So it's a very subjective sort of question at times. But then also, if someone does reveal something about another that is highly private, a judge will then decide whether or not that revelation, that truth, can become the basis for a lawsuit. And often today, judges decide that, in fact, there is the basis for that sort of lawsuit. So it's very much a subjective question of what is news, what is it important for the public to know.
And how exactly can information be determined as not newsworthy?
That's a really great question. And that's part of the struggle here. Those sorts of areas that we've always protected in the United States, nudity, medical information, sexual information, some financial information, that judges are feeling more emboldened, I guess, to second guess today in the age of the internet. It used to be that judges didn't do that as often because they trusted journalists. Today, everyone, in effect, is a journalist. Everyone can publish whatever he or she would like, and so judges are feeling more emboldened again to second guess those sorts of publications.
And in that way, because you say that everybody is essentially a journalist these days, what do you make of some of the backlash that journalists face when they're often just trying to do their jobs but are accused of invading the privacy of others? Is it harder now to be a journalist?
Sure, I think it is. And I think part of the problem is that when judges write these sorts of decisions, they really don't understand what journalism is. They don't understand the ethics involved with journalism and how every day journalists make the call whether or not to report certain things or whether that information is too private, shouldn't be reported in some way. And so I think that the more the public, the more judges really come to understand the role of journalists as opposed to everyday media, someone who might publish something on Facebook and otherwise, the better off journalists will be. We aren't all journalists, and judges need to understand that.
And in what ways has the instant access of social media played a part, would you say, in the tangled history of the right to privacy and freedom of expression?
Sure. Well, social media and its immediacy is certainly of concern to certain judges, and I think part of the reason is because people can post very quickly, and the information then goes out there. There's no level of editorial review before it gets out there, and that's a real problem on social media sometimes, of course, but then also with regard to journalists as well. Used to to be that there was an editor looking at the information, checking it for invasion of privacy, checking it for defamation issues. And that doesn't exist so much anymore. And so you see that level of frustration, I think, within some judges today.
Amy Gajda, we thank you so much for your time and joining us tonight. Amy's book, Seek and Hide, The Tangled History of the Right to Privacy, is now available wherever books are sold.
Hi, everyone. George Stephanopoulos here. Thanks for checking out the ABC News YouTube channel. If you'd like to get more videos, show highlights, and watch live event coverage, click on the right over here to subscribe to our channel. And don't forget to download the ABC News app for breaking news alerts. Thanks for watching.